Welcome to The Explainer. Today, we're going to build something together, a foundation. We're laying the groundwork to understand the complex, layered, and honestly often misunderstood world of Canadian law.
Okay, so where do we even begin? Let's start with a question that sounds super simple, but, well, the answer is anything but. What exactly is law?
Most of us probably learned a definition kind of like this one in school. The law is a bunch of rules the government makes, the police and courts enforce them, and that's that. A nice, neat little package.
But here's the thing. In Canada, if you stop there, you're missing a huge piece of the puzzle. That definition is totally incomplete because our legal landscape is so much richer and more complicated than just what the government says.
So, here's our game plan for this explainer. We'll start with the multiple legal systems that make up our foundation. Then we'll look at the rule book that governs the government itself. We'll see how judges actually make law, untangle public versus private wrongs, and then we're going to look at the serious challenges the whole system is facing today.
All right, first up, and this is a big one. To really get Canadian law, you have to wrap your head around this idea of legal pluralism.
It's a fancy-sounding term, but the idea is actually pretty straightforward. It just means that in one place, like Canada, you have more than one legal system operating at the exact same time, all interacting and shaping our lives.
And for us, that means we're built on three major legal traditions. First, there's Indigenous law, which has been here since time immemorial. Then you have French civil law, which came with the early French settlers. And finally, English common law, brought over by the English.
Now this is where it gets really interesting. Look at the contrast between the two European systems. Civil law, which is what Quebec uses for private matters, is like a massive, detailed rulebook written in advance. It works from the top down. Common law, used everywhere else, is the opposite. It's built from the ground up, case by case. Judges' decisions create precedents that become the rules for later cases.
And this is absolutely crucial to understand. Indigenous law doesn't really fit in that comparison. It's a whole distinct tradition, actually a whole family of diverse traditions that often focus on restoring balance and healing relationships, not just punishing someone who did something wrong. Okay, so we've got these different legal systems. Now let's zoom in on the state's power to make law, and the master rulebook that's supposed to keep that power in check.
And that rulebook is, of course, the Constitution. You can think of it as the ultimate law of the land. It doesn't matter what law a government passes, if it doesn't follow the rules of the Constitution, it's out.
And this right here, this is the hammer. This is Section 52, the Supremacy Clause. It's the part that says if a law violates the Constitution, courts can literally strike it down and say, nope, this has no power here.
Which of course leads to a massive question. The Charter of Rights and Freedoms is a part of our Constitution. So are the rights it protects, like your freedom of speech or your right not to be randomly detained. Are they absolute? Can they never be touched?
Well, the answer is no, but, and this is a huge but, the government can limit a right, but only if they can pass this incredibly high bar called the Oakes test. For instance, the Supreme Court has said that random police traffic stops to check for drunk drivers do violate our rights, technically, but they're a justified limit because they pass this four-part test and the goal of saving lives is important enough.
All right, let's switch gears and talk about the other big lawmakers in our system, the judges themselves.
So, in that common law tradition we talked about, judges are guided by a principle called stare decisis. It's a Latin phrase that just means to stand by what is decided. It's basically like following a recipe. Judges have to use the legal recipes, the precedents, that have been handed down by higher courts in similar cases before them.
And why is this so important? Well, it's all about fairness. This process makes sure that the law is consistent and predictable. It means your rights shouldn't just change on a whim, depending on which judge you happen to get on a particular day.
Our legal system also draws a really clear line between two different kinds of wrongs. There are wrongs against society as a whole, and then there are wrongs that happen between two people.
And this table just lays out the difference perfectly. A crime? That's a public wrong. That's why you see cases called the Queen versus Smith. The state is prosecuting on behalf of all of us. The goal is punishment, and the standard of proof is super high, beyond a reasonable doubt. A tort, on the other hand, is a private wrong. It's Smith versus Jones. One person is suing another to get compensation, and they just have to prove it's more likely than not that they were wrong.
So, okay, we've laid out the foundation, we've seen the blueprints, But now we have to talk about the deep, systemic cracks in that foundation. Cracks that are under intense scrutiny and in many ways exist because of how that foundation was built in the first place.
Over the years, inquiry after inquiry has come to some really devastating conclusions. This quote from the MMIWG inquiry drives home a painful truth. Those colonial structures it's talking about, those are the very common and civil law systems we've been discussing, systems that were imposed on this land, pushing aside indigenous legal orders and causing generations of profound harm.
And look, this isn't just abstract theory. These are real cases with real-world human consequences. The case of R.V. Lee exposed racial profiling by police. R.V. Kokopane showed how the jury selection process was systematically failing to include indigenous people. And the tragic story of Fallon Abbey, a transgender woman who died in a men's prison, exposed a system that can fail to protect the most basic human rights.
And if you need to see the impact in one single staggering number, here it is. Indigenous people are about 5% of Canada's total population, but they make up over 30% of our federal prison population. That incredible overrepresentation shows a fundamental clash, a clash between a state system focused on punishment and Indigenous legal traditions that prioritize restoration. Reports like the Truth and Reconciliation Commission's calls to action see this not just as a statistic, but as a crisis that demands immediate, fundamental change.
Our courts have this beautiful metaphor for the Constitution. They call it a living tree, something that can grow and adapt as our society changes. But that leaves us with a really profound and difficult question. For a legal system that has such deep, varied, and even conflicting roots, how do we make sure it grows in a way that truly brings justice, healing, and fairness to everyone?